Good morning. I'm Pete Blyler and a member of the OSHER at Dartmouth Summer Lecture Series Committee. I'm excited to bring you another session from last year's series entitled Critical Thinking for the Preservation of Our Democracy. As I mentioned earlier this summer, we used a debate format in 2019 and had two speakers for each session. In general, one speaker talked on one side of the issue or issues, while the second speaker spoke on the opposite side. Today's session is on affirmative action. Most U.S. colleges have implemented special affirmative action admission policies where academic achievement is only one factor in the determination of who gets accepted. This is designed to generate a student body with more economic, racial, sexual, and global diversity. These colleges claim their broader student diversity pool results in enhanced multicultural understanding and critical thinking. Opponents of these policies claim that they unfairly discriminate against applicants with better academic qualifications and thus are a violation of civil laws. During last year's session, we had not yet learned of the judge's decision in the affirmative action case that claimed that Harvard University was discriminating against Asian American applicants. This lawsuit was discussed during last year's session. In October, the judge rejected the plaintiff's claims, ruling that Harvard's admission practices meet constitutional requirements and do not discriminate against Asian Americans. This ruling was appealed to the First Circuit Court of Appeals in February, and it's expected that the decision will likely reach the Supreme Court. Our first speaker this morning is Neal, a partner in the Hogan Lovells law firm and a professor at Georgetown University School of Law. Neal graduated from Dartmouth and obtained his law degree from Yale. He served as acting Solicitor General of the United States under President Barack Obama and has argued 37 cases before the U.S. Supreme Court. He represented private law schools in the landmark Michigan affirmative action case, Grutter v. Bollinger. The American Lawyer has consistently named Neal one of the 50 top litigators nationally, and Legal Times has rated him as one of the 90 greatest lawyers over the past 30 years. Our second speaker is Adam Mortero, a partner in the Bartlett Beck law firm in Chicago and a lecturer at the University of Chicago Law School. Adam earned his bachelor's degree from the University of Chicago, a master's degree from Cambridge University, and his law degree from the University of Chicago. He has clerked for Clarence Thomas, one of the justices of the Supreme Court, and has been voted Lecturer of the Year at the University of Chicago Law School. He was also recognized as an Illinois Super Lawyers Rising Star. He is a very successful litigator in major intellectual property law cases and was the co-lead litigator in the affirmative action case against Harvard University. He's now continuing with the appeal of that judge's ruling in that case. Both of these speakers have provided updates to last year's discussion, so please enjoy the session on affirmative action.
Thank you. It is such a delight to be back at my college in my favorite town, and so thank you for all of you for showing up today. So what I'm going to do is a limited defense of affirmative action. I'm going to defend affirmative action the way the Supreme Court has defended it ever since the Bakke case in 1978. And what that is a defense of affirmative action in the higher education context. I'm not going to try and defend it in other places like government contracting or the like, where I think the arguments are very different. Indeed, I think that we could think about three kind of fundamental distinctions, and this is what the Supreme Court has been focused on for the last 40 years. One is that when you're thinking about government contracts, they're susceptible to fraud, and so you could have an affirmative action program, as many states and localities, and indeed even the federal government did, that set aside a certain percentage of contracts for minority owned firms. The problem is sometimes those will be fraudulent. There'll be a figurehead who's owning the firm on paper, but not actually in practice. That's obviously harder to do. There is a little bit of fraud, obviously, in college admissions, but it's not dramatic. To the extent there is fraud, it's not on the race side as much as it's on other sides. A sensitive topic, I know, but I do think in general that fraud over race is constrained in the university application process because you've got guidance counselors, teachers, school administrators, and the like, as well as the student actually shows up for 4 years, and you can often figure out if there's some sort of lie on the application or something like that. The second is that a more fundamental difference is that affirmative action in government contracts or employment, there's no logical stopping point. When does it end? Do you always give preferences to folks throughout their life? I think by contrast, the vision of affirmative action that the Supreme Court has blessed in the higher education context is this idea that you have a university of education, which typically occurs early in life and then ends in higher education by making up for educational inequities at earlier stages in life, can be the ramp up to a level playing field. And then the third but most fundamental difference between affirmative action here and in other spaces has to do with the benefits of diversity. And when you have a government contract, you're often balkanizing the races. You're saying that minority firm gets that, installs the guardrails, and that firm, lays down the tar or something like that. There's no emphasis on integration, but that's what university affirmative action is all about. That is its goal. Integrated education it's not just for the minorities. It advantages all students in a distinctive way by bringing rich and poor, black and white, urban and rural together to teach and learn from each other. And if a far-flung democracy is diverse and indeed at times divided, as America is right now, if it's to survive and flourish, it's got to cultivate some common spaces where citizens from every corner of society can come together to think and learn together and learn how others feel. If not our universities, then where? And if not in young adulthood, then when? So that's Justice Powell's vision in the Bakke case back in 1978. That was a case in which Alan Bakke challenged a university program that set aside 16 slots at the UC Davis Medical School for minority students. And he was a white student, not admitted, and he said this was unconstitutional. And Justice Powell cast the deciding vote, and he said that the Davis program was unconstitutional, but that there was a right way to do it. He said that there were benefits of integrated education that benefit all students, and that some affirmative action to increase diversity was therefore appropriate. He said, quote, "The goal of a diverse student body clearly is a constitutionally permissible goal for an institution of higher education. It's not too much to say that the nation's future depends upon leaders trained through wide exposure to the ideas and mores of students as diverse as this nation of great peoples." Now, diversity wasn't some magical phrase to Justice Powell, some get-out-of-jail-free card that you could just say if you were a university and escape, scrutiny. He said, basically, that indeed he struck down the Davis program because he said the fatal flaw of the program was, quote, its disregard of individual rights because it tells applicants who are not Negro, Asian, or Chicano that they are totally excluded from a specific percentage of the seats in their class. And so there's essentially 3 points that Justice Powell made, and that these are the cornerstones of affirmative action programs in many of our leading universities today, and I think that they're right. So the first point he makes is that diversity can enable an educational affirmative action program to survive constitutional muster because the democratic and dialogic benefits benefit all students. That they, as Justice Powell said, you have to admit sufficient numbers to bring to their classmates and to each other the variety of points of views, backgrounds, and experiences of blacks in the United States. Second, he said, a university can't use a strict quota or a set-aside because instead the university has to look to the whole person And indeed, Justice Powell attached an appendix to his decision which outlined the Harvard College program in effect at the time, saying that was the right way to do it. It wasn't just some rigid percentage that goes to minorities or something like that. And then the third thing Justice Powell said is that there had to be an interest in non-racial diversity, that it wouldn't be credible if a university just trotted out diversity when it came to race, but not to other things, urban and rural, political and liberal, all the other matrices of religious, non-religious orientation, all the other matrices of diversity that are so important, that are part of this story for learning from each other. And that's what he said the Harvard plan was all about. And indeed, these arguments are intermeshed with each other, these 3 points that Justice Powell made. One reason that a university can't use a rigid quota is because if it does so, it may lead a school to admit unqualified minorities who aren't going to be able to further that educational mission of teaching students. And so in Justice Powell actually, and I'll stop the Bakke discussion with this, he actually quoted from the president of Princeton in a footnote and said, quote, "A great deal of learning occurs informally. It occurs through interactions among students of both sexes, of different races, religions, and backgrounds, who come from cities and rural areas, from various states and counties, who have a wide variety of interests, talents, and perspectives, and who are able directly or indirectly to learn from their differences and to stimulate one another to re-examine even their most deeply held assumptions about themselves and the world." And I can tell you, that resonates incredibly powerfully with me, including when I was here as a student. And that was the first time, I was from Chicago, first time I encountered some minorities. It was the first time I encountered openly gay people. And boy, those lessons did stick with me. And I can talk about my experience as an educator too, but I think that there's something pretty dramatic when you come to a place that intentionally curates and brings together people who think differently, act differently, are from different places than you, and yes, indeed, have a different skin color than you. So there's, I think, 3 interlaced policy points that I want to conclude with that I think mount the defense of affirmative action. One is, I think it's very important to think about the different in how you do affirmative action. As Justice Powell said, quotas versus pluses. It's a real problem when you have an affirmative action program that literally sets aside a certain number of seats for minorities, either in the university setting or any other. Just because of his skin color, Alan Bakke wasn't able to compete for 16% of the seats at Davis. That strikes me as fundamentally wrong. You can't have minority applicants segregated into some separate admissions compartment where they only get to compete against each other and not against the entire pool. Instead, I think universities have and should be adopting affirmative action programs that treat diversity, racial diversity, the way they treat other forms of diversity. Diversity, Texans or chess players or flute players or football players or whatever. Background and life experience are positive life attributes, and growing up Amish or something like that, and it's neither unfair to Caucasians nor stigmatizing minorities to consider these factors so long as they don't become the only thing or the dominant thing that the admissions committee looks at. And if you think about diversity that way, if you think about racial diversity in the same way as you think about being a good violinist or a great football player, then I think it's easier to understand the preference. The second thing is the democratic benefits of diversity in education. Much of the point of education is really to teach students how others think and how others feel, and how to be a responsible, sovereign, informed citizen in our heterogeneous democracy. And a school is admitting students in large part to be teachers to other students. That's what they're doing. And SAT scores and GPAs are only a rough proxy at best for that. And if a university wants to teach people, say, about France, it's probably a good idea to admit some students from France. And if they want to teach people about the South, it's a good idea to admit people about the South. And so the university experience is very different from the kind of attenuated relationships that exist in the employment setting. because I think it's much harder to justify those types of diversity-based initiatives. Because integrated education benefits people of all races, including white students, by providing a space for people of all races to grow together. And in that sense, I think it can be said that Bakke and this kind of affirmative action been built squarely on the root of Brown versus Board of Education. After all, Brown actually said that education was sui generis, was different, and should be treated differently than other spaces. And indeed, it didn't even technically overrule Plessy versus Ferguson, the notorious 1896 case about separate but equal race cars. The idea was start in education because that's the place that is so important. And inherent in the concept of this kind of affirmative action is a theory of value. It's a theory that says that a minority student actually comes to campus and benefits not just the minority student, but all students. It's harder to make those kinds of arguments in the employment setting. It's not impossible, but it's harder. And in my judgment, affirmative action, and I've seen this, having now taught for 20 years, in education, affirmative action education is a very powerful long-run antidote to the poisonous race discussions that we've been having throughout our history, and increasingly so in the last couple of years. There are some pretty good studies on this. I mean, one just done by the military, or I should say not a study, but a brief filed by our nation's leading military officials in the affirmative action case Grutter said, quote, "There's no race-neutral alternative that will fulfill the military's and thus the nation's compelling national security need for a cohesive military led by a diverse officer corps of the highest quality to serve and protect the country." And they filed a brief, came in and said, we need affirmative action in order for strength in our military because diversity is part of our strength. Our nation's top corporations have all filed briefs as well, saying similar things in the recent Fisher versus University of Texas case. Senior leadership of over 50 Fortune 100 companies said you need an affirmative action system that teaches students how to work in diverse workplaces. As they say, quote, for the 50 companies amici to succeed in their businesses, they must be able to hire highly trained employees of all races, religions, cultures, and economic backgrounds. It's critical that all of these university-trained employees have the opportunity to share ideas, experiences, viewpoints, and approaches with a diverse student body. And there's many studies done, Harvard Graduate School of Education, others showing that a diverse educational environment leads to better outcomes for the students in terms of future employment perspectives and also how they do at the job. And finally, there's, I think, important studies about unconscious bias and how students who go to more integrated schools tend to have reduced implicit bias and the like. The final point I'd make is this. Much of the debate about affirmative action concerns universities such as Harvard, and you're obviously about to hear from an expert, and I won't pretend to know what Harvard is doing, and being a Dartmouth guy, I don't particularly care. But these are private institutions. And I do find it very odd that many conservatives who I thought were believers in free markets now want to come in and say, oh, no, you can't do that one thing. We have to regulate. And in general, I think markets can regulate this for themselves. It's telling to me that every major university has affirmative action programs. If students didn't want them, then I suspect that there would be other schools that would crop up and people would gravitate toward those schools. But I think there's a reason why you see so many of our nation's top universities adopting affirmative action programs, not Johnny-come-lately, but for decades. And the reason is because they want to train their students to be the best possible leaders in our diverse country. And so there is a proud educational tradition in this country that treats schooling different, that education is different, it's special, because it teaches Americans how to be full citizens in a pluralistic society. And under a Constitution that has as its core vision, we the people coming together in order to form a more perfect union. E pluribus unum, what does that mean? It means out of many come one. This coming together of Americans in our university settings is a deeply inspiring event to behold, and I think it's critical to the future of our nation. Thank you.
Well, thank you for your remarks, Neal, and it's wonderful to be here on my first ever visit to Dartmouth and to Hanover. My wife and daughter and I were walking around yesterday, and as we sort of came through campus and up into College Park and got to the statue of Robert Frost that was donated actually by Peter's class, I turned to my daughter and said, how about Dartmouth for college? And I was trying to get her interested, but I'm ashamed to report to this audience that her heart is still set on Bowdoin. I will see what I can do. I want to thank the organizers of this great event, particularly John and Peter, for the invitation and for the opportunity to talk to you a little bit and maybe surprise you some. And I want to do my best to start off and reframe the discussion so we're clear about what Neal and I agree and disagree about. Title VI of the Civil Rights Act of 1964 says the following: "No person in the United States shall on the ground of race, color, or national origin be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance." You may not know that fewer than 3 colleges or universities in America do not accept federal money. So essentially we are talking about every college and university in America is bound by the statute I just read to you. And to everyone here, these words are pretty easy to understand. They express a public policy that no one should be judged based on the color of their skin in the context of higher education, including admissions. That's what we as a nation agreed to in 1964 through an act of our Congress. And actually, we as a people agree with this principle today, even if a majority of people sitting here do not. According to Pew this year, over 70% of Americans oppose the use of race as a factor in higher education admissions. So if the market is speaking, it speaks in the form of you and me, people answering the phone to Pew, saying we do not agree that universities should use race as a factor in admissions. And I recognize this is not the way people tend to think about race on college and university campuses and in the faculty conference rooms, where every day and in every way there are bombardments about topics like white privilege, intersectionality, other concepts to that effect, where race is not something to be put aside, but is in fact a central obsession. But I don't intend to win this debate by appealing to you to join your fellow 70% of Americans who think race should not be used as a factor of admissions or to engage in some kind of groupthink or persuasive authority by reference to that. I will win by delivering to you two what I think may be surprises. And surprise one is that I agree with about 90% of what Neal said. No one thinks, or very few people think, it would be healthy for America, for Harvard or Dartmouth or Yale or Princeton, to have few or no African Americans on its campus. No one believes that. I don't believe that. Harvard and, of course, its peers like Dartmouth serve an incredibly important gating function along the lines of what Neal was talking about, but even further, these elite institutions serve an important gating function in our society. A degree from one of these institutions, as many of you know, opens doors. You get to come here or go to Harvard or go to Yale and rub shoulders with future titans of industry, future presidents of the United States even. So we can all have an aversion to these important social vehicles, Harvard, Dartmouth, Yale, locking out a minority group or in some way preventing that minority group from achieving those benefits, and by supplying benefits to everyone else, as Neal outlined. I think all but the extreme fringes in our society would agree with what I just said, and I agree with Neal. So we're not here to debate whether an all-white Harvard or an all-white Dartmouth is a good or a bad thing. We agree it's bad. We're here to debate whether applicants need to be sorted and judged by their skin color in order to achieve the great benefits of diversity Neal has talked about. Now let me make sure you know what I mean by sorting or judging and what everyone means by race-based affirmative action in higher education. Daniel helpfully read out a definition of affirmative action, But the way race-based affirmative action works is uncontroversially and absolutely without dispute as follows. Someone applies to college. Many of you have children or grandchildren that have applied to college. They now use something called the Common Application. The Common Application has a space for you to indicate your racial or ethnic background. You check a box that says you are African American. You say nothing else about your race anywhere on your application. But a university uses the fact of your skin color alone, your self-identified skin color, to award you a preference in admissions. It doesn't matter whether you're a student at hyper-ritzy Georgetown Day in Washington, D.C., and you happen to have black skin and be African American, versus an African American student from my hometown of Chicago who literally dodges bullets on the way to a school that has no books. Those two people are treated the same for purposes of this analysis. They are both awarded a preference based alone on their skin color. I want to make clear, I have no objection to a college or university considering someone's personal history with respect to their race. For instance, whether they've suffered discrimination in the context of university admissions. But that's not what we're talking about. What Students for Fair Admissions is trying to make illegal is considering the mere act of checking a box, the mere fact of someone's skin color. So what's the second surprise? First surprise is I agree with 90% of what Neal said about the benefits of diversity. The second surprise is really the important one. None of this skin color preference is necessary to achieve the benefits Neal is talking about. And how do we know that? Well, for decades, we've had universities submitting briefs to the Supreme Court, like Harvard's in the Bakke case that Neal talked about, with abstractions about how important the consideration of race is to their process and how they couldn't get by without it. Well, the good news about a lawsuit against Harvard is they can't deal in self-serving abstractions anymore. And what we managed to get is massive amounts of data. So the court ordered Harvard to produce the copious data it had on its admissions process. And when I say copious, I mean that we ultimately got 6 years' worth of data, 150,000 admissions decisions, about 10,000 admits over a 6-year period, and incredible amounts of data about each and every one of these students who applied to Harvard, where they went to high school, what the demographics of that high school was, what were their SAT scores, what were their GPAs, what specific extracurriculars did they do, how did Harvard evaluate those extracurriculars, how did Harvard evaluate everything about them? They keep score. We got all that. And what did we find out? We found out that Harvard could stop using race, using skin color as a factor in admissions, and still enroll a class that was as racially diverse, was more socioeconomically diverse, and was equally academically prepared. Now, like I said, only the extreme fringes would believe it would be good for Harvard to have few or no African Americans. I don't even know these people. You don't either. I think also only extreme fringes would want Harvard to keep judging people by the color of their skin, to keep awarding an African American from Georgetown Day some kind of benefit in admissions when they've seen no disadvantage in their life. No one would want Harvard to keep doing that if they could get by without it. So this all sounds so easy, you say. So what's the catch? Why are we here? If Harvard could stop, why don't they stop? How does Harvard justify what it's doing if everything is the way I say it is? How did we get here to this point in higher ed admissions if there are easy alternatives? Here's how we got here. And on these subjects, I will speak only about Harvard, but I really have no reason to believe it's any different at any of Harvard's peer institutions, particularly in the Ivy League, but also across the country. Why does Harvard resort to the crude use of a skin color preference in order to enroll a racially diverse class today? It is to offset Harvard's white preferences. Yeah, you heard me. Harvard currently awards massive preferences for recruited athletes, children of its alumni, children of major donors or relations of major donors, and children of its faculty, what we call the ALDC group, athletes, legacies, donors, children of faculty. This group is over 80% white. That's no surprise. Actually, most of the athletes at Harvard are white. Certainly, most of the legacies, obviously, most people who went to Harvard still today living are white, and their children are white. People with money are white, and most of Harvard's faculty, white. So it's no surprise that this group that gets its massive preference is 80% white. They make up just 5% of Harvard's applicant pool. And I don't know if anybody wants to guess, 5% of Harvard's applicant pool, what percentage of the entering class do you think these 80% white, privileged people, children of rich people, children of Harvard alumni, what percentage of Harvard's class do you think they are? 5% of the applicant pool. 30%. They are 30% of Harvard's entering class, this group that receives these preferences. And it gets worse. Of the 30% that we're talking about, this white privilege group, which is really what it is, this privileged preference group that's in Harvard's class, 3/4 of them, 3/4, would not have been admitted if they'd competed with everybody else. That is absolutely the analysis that will be coming out in papers that will be peer-reviewed as soon as the court issues its decision. This is public record. You can look all of this up in the analysis of the case. 3/4 of them. The size of this ALDC preference has not been getting smaller over time. It's actually been getting bigger. In other words, as it's increasingly the case that this privileged third of Harvard's class could not have gotten in without dollars or connections from mommy, daddy, grandpa, or coach. 80% white, 5% of the applicant pool, 30% of the class. And that means about 1/4 of the class is de facto set aside today for white faces. And now you know why Harvard claims it needs to be able to resort to skin color preferences. It's got to balance it out. They've given away 1/4 of the seats to whites out of the gate. I told you we proved that Harvard could get to a racially diverse class without using the skin color preference it uses today. What we actually showed is that all Harvard would have to do is 2 things. Get rid of the privilege preferences and increase preferences for socioeconomically disadvantaged applicants. The first one's easy to understand. All of a sudden, 25% of the seats that have been reserved for whites through privilege preferences are open. The second one is also pretty easy to get. Socioeconomic advantage is not evenly distributed by race in America. We all know that. Racial minorities are disproportionately disadvantaged. Those 2 things would have Harvard with the exact same, very similar racial diverse class, 1% drop in average SATs. I think they could probably deal with a 1% drop in the average SATs, and far, far greater socioeconomic diversity. So the very wealthy African-American kid that I keep referring to who goes to Georgetown Day no longer receives a preference, but maybe my near neighbor in Chicago who through all adversity gets a decent score on the SAT, gets through that school where there weren't even any books or was chronically underfunded, he gets a big benefit irrespective of his skin color. That's the system we proposed. That's the one Harvard could use. That's the one Harvard doesn't want to use. This is not a battle about whether Harvard should be racially diverse. It's a battle about whether these privilege preferences are justified or could ever justify a race-based admission system. Harvard cannot justify these preferences to the American public. They are morally repugnant. Maybe another 70% winner with the American public will ask Pew, is that Congress should ban legacy and donor preferences in college admissions. Maybe somebody in Congress who claims to care about the 99% should propose such a ban, just like we have in Title VI, a ban on race discrimination. That ban would overnight end the false perceived need for race-based affirmative action at elite campuses across the country. Of that, I'm sure. How important are these privilege preferences to Harvard? Well, they refuse to give them up, and they decide they have to use skin color preferences to make up the balance. But as Harvard's non-ALDC applications have gone up, the quality of those non-ALDC applications has gone up, and Harvard has responded to that by increasing the size of its ALDC preference. In other words, as the quality of the rest of the pool gets better and better and better, Harvard makes sure they're still going to have 30% of the class as an ALDC component. What else did Harvard do? Harvard committed a horrible crime against young Americans who happen to be Asian and discriminated against them in admissions. Asian Americans are our fastest growing immigrant group. They too would like to participate in the American dream. And one dream that some people have in America is to go to Harvard. Sorry. Asian American applicants to Harvard and I can assure you this is true of applicants to Dartmouth College and to peer institutions, blow away white applicants on every metric, whether it's the GPA in high school or the SATs or whether they're national merit scholars, but they also blow them away on extracurriculars. We know this from the Harvard database. They absolutely destroy comparable white applicants, SATs, academics, extracurriculars, everything. But what did he see at Harvard? For decades, for about 15 years, there were no increases in Asian numbers at Harvard proportionally, even as Asian Americans were dramatically going up as largest growing immigrant group, higher college applications. And what happened is David Brooks in late 2013 drew attention to a piece that had been written by a guy called Ron Unz, who's a Harvard graduate, in a magazine few read called American Conservative. And Mr. Unz had some wild ideas, but amongst the things that he said was that Harvard was discriminating against Asians, and he could prove it from public data. David Brooks picked this up, and what then happened is, because people do read the New York Times, Harvard's admissions office started to get lots of calls, lots of interest in, well, was this true, or how are we going to respond to this? Both sides, some just reflexively defending Harvard, others asking questions. And here's what happened. Harvard's admissions office went into a near panic mode. They consulted Harvard's Office of Institutional Research, which is an internal arm of Harvard dedicated to studying Harvard itself. Harvard uses these PhDs to collect data and crunch numbers for the federal government, excuse me, and the admissions office asked them to conduct a study. They got 10 years of admissions data, even more than we had, and did an analysis similar to the one that we did, crunched all the numbers, and submitted to Dean of Admissions Bill Fitzsimmons a memo. And the memo said, at the end, we give preferences to athletes, we give preferences to legacies, we give large preferences to African Americans, Native Americans, and Hispanics. We give preferences to small ones for today, to socioeconomically disadvantaged folk, and there is a penalty in our process for Asian Americans. And at the end of the memo, there was some guidance for Dean Fitzsimmons. It said, please don't release this publicly, because the size of the preferences we're awarding for legacies and athletes may be embarrassing. And also there are demographic groups that have negative effects. And the only demographic group with a negative effect in that formal memorandum he received are Asians. And so you would think, if anybody working in any business, if Neal or I at my law firm, at our law firms respectively, got a memo saying we crunched the numbers and we're discriminating against Asian Americans or African Americans in our employment practices, I know, I just met Neal for the first time today, and I know what he would do. He would run off to management. He would say we have to do something. He would say we need more analysis. He would say I'm worried. This is surprising to me. Dean Fitzsimmons told absolutely nobody about that memo. He conducted no further analysis. He asked for no further work. He did not tell the director of admissions, Marlon McGrath, who he'd been working with for over 3 decades, about these findings. He told no one. Harvard did nothing. That was before we sued them. That is not the act of someone who believes themselves to be innocent. That is not the act of someone who cares about whether there's a problem. They didn't care. Dean Fitzsimmons didn't care that Harvard was discriminating against Asian Americans. And the main mechanism by which they do so, by the way, is that I told you Asian Americans were better on academics and extracurriculars and everything that matters to getting into Harvard, except one thing, which is Harvard uses something called a personal rating, which is the Harvard Admissions Office assessment of how likable, vivacious, interesting you are. And Asian Americans were systematically awarded lower personal ratings than white applicants. Yes, absolutely. Things would get written on the docket. Seems quiet. Of course, wants to be a doctor. Racial stereotypes deployed against Asian American applicants. Racial stereotypes are bad no matter where they're found. It doesn't matter that Asian Americans are the so-called model minority, and they're doing so great because they're 5% of the population, and at the time were about 18 or 20% of the population at Harvard. That doesn't excuse deploying racist stereotypes against individual kids who've done nothing wrong, and maybe they aren't quiet. Why are you assuming that? Maybe they'll change their mind about wanting to be a doctor. And what's wrong with wanting to be a doctor? I think Dan told me his dad was a doctor. There's nothing wrong with it. This is what happens when you give people the tool of skin color preferences. They are allowed to preserve that which they're embarrassed about, these privileged preferences. They're allowed to engage in penalties against vulnerable and immigrant minority groups like Asian Americans. It's not just Harvard, though. In the University of Michigan case that Neal referred to, a Michigan administrator was heard to remark that Cubans shouldn't get any affirmative action because they're Republicans. In Students for Fair Admissions litigation against the University of North Carolina, cavalier and frankly gross statements are made about race. Let's give these brown babies a chance. That's a direct quote from documents Students for Fair Admissions obtained from the University of North Carolina. It's high time we stopped trusting higher ed's assurances that race-based preferences are needed. The Harvard litigation has proven that one of our nation's best colleges has lied through its teeth about this for decades. Ashamed of its privileged preferences, Harvard hid the truth that its decision to set aside a quarter of its class for white faces is what created the false need for affirmative action. Even worse, it led Harvard to deploy awful racial stereotypes and impose an admissions penalty on Asian American applicants. It is time for this to stop. It is time for privileged preferences to end and for the toxic weapon of race discrimination to be eliminated from higher ed admissions, just like Title VI of the Civil Rights Act of 1964 says. Thank you.
Hello again. A virtual thank you to Neal and Adam for their discussion on affirmative action, which occurred last year on July 25th. More recently, both speakers have recorded an update, and each is about 5 to 7 minutes in length.
Hello, and thank you very much for welcoming me back for this update on the wonderful debate we had on the Harvard affirmative action case. I'm Adam Mortara. I'm glad to be back with you from the safety of my home office. I hope that everyone is staying safe and doing well during this pandemic. I have a few updates to give you, one of which you're probably aware of, which is that back in October of 2019, the District Court, Allison Burroughs, ruled against Students for Fair Admissions, my client, and found that Harvard's affirmative action program was legal under the United States Constitution as applied to Harvard through the vehicle of Title VI of the Civil Rights Act of 1964. Title VI, which I'll return to, bars discrimination on the basis of race in higher education admissions for institutions that accept federal funding. As I said, Judge Burroughs found Harvard's program was lawful, and she did so making a couple interesting observations along the way that I'd like to share with you. The first interesting observation that Judge Burroughs made is, you'll recall in the debate that we had, I had made the point that Harvard had never explained adequately or at all why it is that Asian American applicants to Harvard got lower personal ratings than white applicants. Across the board, no statistical explanation for that was given. No explanation at all was given. Judge Burroughs provided an explanation by speculating, in her opinion, that in fact Asian American applicants to Harvard had inferior personal qualities. And I want to just stop there. That's a stunning suggestion. It is in fact unsupported by any evidence anywhere, and it is based itself on a racial stereotype. With all respect to Judge Burroughs, and I do want to be respectful, I have a great deal of respect for her, she attempted to say, well, maybe it's not all Asian Americans, but it's just those that apply to Harvard have something wrong with them or have inferior personal qualities. She really had no evidence for such a suggestion. And I think that there you see one of the ways in which Students for Fair Admissions, as we pursue the case on appeal, have and will point out that racial stereotyping of Asian Americans is alive and well. It's alive in Harvard's admissions program, and it's actually alive in a footnote in Judge Burroughs' opinion. Another observation Judge Burroughs made was that the harm to Asian American applicants, and I should point out that Judge Burroughs agreed that under the statistical analysis presented by both sides' experts and the statistical analysis that the court ultimately adopted, there is an Asian penalty in Harvard's admissions system that is inexplicable by her or by Harvard. But she found that the penalty was small enough, only about, under her analysis, 20 to 30 students a year not admitted to Harvard because of their race, that was outweighed by the dramatic benefits Harvard gets from using race in its admissions process to achieve diversity on campus. And I'm not going to spend a lot of time talking about the fact that Harvard massively overuses race in its admissions process in a way that's unnecessary. We talked about that when I was there last summer, about a year ago, about how Harvard maintains this legacy in white preferences, and in so doing creates the perceived need to use race to get more diversity back, because what Harvard is really doing is setting aside about 30% of its places every year for white faces, and that's what creates the diversity problem. Legacy and donor preferences creates the diversity problem. But no, I'm going to talk a little bit about Judge Burroughs' really profoundly new idea that you can racially discriminate a little bit, and if you get benefits from other racial discrimination elsewhere, the benefits for African Americans and Hispanics largely, that somehow, some way, that justifies the discrimination against Asians. That's what she said. That's a brand new proposition of law, never before heard, and it's going to be interesting to see how the courts of appeals deal with that as we proceed with the case. And that gets me to a little bit of an update on what's going on with the case. Well, we are at the First Circuit Court of Appeals based in Boston. Our case is now fully briefed, and we expect it to be argued sometime before the end of 2020. Whether that argument is live in Boston and you can take the short drive and see it, I don't know. I suspect it will be telephonic or over a medium such as the one in which I'm talking to you right now. That will happen by the end of the year, and then we'll see what the Court of Appeals does with the case. The Court of Appeals gets to rule, and then one of the other party will be off, presumably, to the Supreme Court of the United States, where I do have another interesting update for you. Two things have happened in the Supreme Court of the United States this year that have a real interesting impact on this case. The first is a discrimination decision that I'm sure all of you have heard of, called Bostock, in which the Supreme Court held that Title VII of the Civil Rights Act's prohibition on discrimination on the basis of sex extends to discrimination on the basis of sexual orientation and gender identity. And if you go and read Justice Gorsuch's opinion in Bostock, what you will find in there is very strong language interpreting the text of Title VII, the anti-discrimination in employment statute, in an extremely hyper-technical way that brooks no compromise. And you will find in there several statements that indicate that discrimination is discrimination is discrimination. What does that mean? That's a strong indicator that Justice Gorsuch and perhaps Chief Justice Roberts, who joined him, might take the same view of Title VI, which has extremely similar language and no exception written into it for affirmative action, an exception that the Supreme Court itself has repeatedly read in. Another interesting development of the Supreme Court over the last term was actually in a criminal case called Ramos against Louisiana. In Ramos, the Supreme Court overruled its prior precedent allowing for Louisiana and Oregon to have non-unanimous criminal jury results. So you could have an 8-1 verdict finding a defendant guilty. Usually in every other state, you have to have a unanimous guilty verdict in order to send an accused prisoner to his sentence to prison. In Louisiana and Oregon, you did not need to do such a thing, and the Supreme Court overruled decades of precedent allowing for non-unanimous criminal jury verdicts in this Ramos case. Well, why is that relevant to Harvard? In discussing the ruling, again, Justice Gorsuch went through painstakingly the history behind Louisiana's adoption of a non-unanimous criminal jury verdict process, including that history was steeped, in his view, in efforts at racial discrimination. Well, why is that important to Harvard? Judge Burroughs, our trial judge, often remarked that she felt that Harvard's disgusting legacy of discrimination against Jewish applicants had nothing to do with this case because it was so old. And yet Harvard admitted that it adopted its current holistic admissions policy because it wished to discriminate against Jewish applicants in the 20th century, in the early 20th century. Well, that history now, thanks to the court's decision in Ramos, will be important to the resolution of this case. And if you go and read our briefs at the First Circuit, you will find that Ramos features prominently, and I guess it would continue to feature prominently as the case continues. So we've had some updates from the trial court. We've had some interesting observations. We see that racial stereotyping against Asian Americans is alive and well. And we've had some interesting, perhaps, hopefully, prophetic comments from the United States Supreme Court. I want to thank everyone out there in New Hampshire for the lovely visit that my family and I had last summer. And again, hope and pray that all of you are well and keeping well during this time. Please feel free to contact me if you wish to further discuss the case. And again, all the best for the remainder of this year and beyond. Thank you.
This concludes today's session. Next week, our last session is on Brexit, and the speaker is Julie Smith. Have a good day.